All right, should be recording then, great. So we've got a jam-packed agenda tonight, so let's go ahead and get started. We'll just do real quick introductions because there's some folks on here that not everybody knows, and we have a new group of mediators. So if everybody could just go around and just say their name and who they're mediating for, or if you're not mediating, what you do. So I'm Sherry Tardio, and I am the director of the Community Mediation Center of Calvert, and I've been mediating since 2012. And let's see, I'll pass it on to John.
John Roberts. I mediate in both counties, and I've been hanging around since the year 2000. Old time.
And who should go next, John?
Oh, pardon me, Dusty Rhodes.
Hi, everybody. Dusty Rhodes, mostly in Calvert, although we've, Vicki and I have mediated in both counties. We've been doing this since about 2001, not quite as long as John.
Hi, I'm Vicki, and we'll pass it on to Allie.
Hi, I'm Allie. I worked for the St. Mary's County Mediation Center for about a year, and I'm still with St. Mary's, and I've been mediating for about, I think, almost 2 years now. And I'll pass it on to Pam.
So I am Pam Jameson. I mediate with St. Mary's County. I have been a mediator for several years and then took a little bit of a break when we moved, and now I'm back. So I'm excited to be back. Yeah. I will pass it on to Lakita.
Hi, Pam. Thanks for passing it on to me. It's good to see a face from the past. I'm Lakita Younghill. I am a mediator in training. I guess I have maybe 3 more hours after today. I am associated with the St. Mary's County Mediation Center, and I'm so sorry I'm not on video, but I was off today. So a little bit of a bad hair day. And I will pass it on to, let me see, Jean Marie.
I'm Jean Marie, and I'm a mediator in training for Calvert, and I will pass it on to Malcolm.
Are you there, Malcolm? Uh-oh, wonder if Malcolm's having trouble again.
Okay, I will pass it on to Frederick.
Hi, I'm Fred Tutman. I've been mediating in Calvert for, I think, just about 2 years now. Not sure who to pass it on to. I don't know. That's a good question. Eeny, meeny, miny, mo. Bueller. Is there anyone out there that I've lost track of who's spoken and who hasn't? That's my confusion. There you go, Christine. Christine, you're elected.
Thanks, Fred. I'm Christine Bergmark. I mediate with the St. Mary's County Mediation Center. I started in 2017. And I just want to brag a little on Allie, because Allie didn't tell you that she got her junior mediation certificate when she was in at the Chesapeake Charter School. So she's actually been mediating for longer than just 2 years. And she happens to be my daughter. So I'll pass it to Jamie.
Thank you, Christine. My name is Jamie Coster. I mediate in St. Mary's County. I've been mediating as long as Christine. In fact, we took training together. And I've mediated several times with her daughter, Allie, and she's very good. She may be young, but she's a very, very good mediator. So anybody that has the opportunity, I think you would enjoy it or get a lot out of it.
Who do you pass it to?
I think that's everybody. Oh, I'm sorry, Emma.
Hi.
Oh,
I don't have much. My name is Emma, and I'm just starting. This is my first time, and I took a class in mediation, and it was fun, and it was awesome, and I really want to kind of try and see what's next. And then I don't know who hasn't gone. I'm sorry.
Joe.
Laura. Laura?
Hi, everybody. I'm Laura. I mediate in St. Mary's. Been mediating for a few years, and I don't think maybe Katrina's had a chance. So I'll pass it to Katrina.
Hello, everyone. My name is Katrina. I'm scene, and I have been doing the trainings for some time now. I'm enjoying it. I'm in the St. Mary's County area, and I work at Walden. Okay, I will pass it on to, I apologize. Okay, Miss Jennifer.
Hi, I'm Jennifer Holt. I'm part of the new class of mediators that's still getting trained, and I'll be with the St. Mary's County Mediation Center. And I will pass it on to Marisa.
Great, thanks, Jennifer. Marisa Sanchez. I'm also a mediator in training, and we'll be working with the Calvert Center. Now I'm going to pass it on to Jeff.
Thanks, Marisa. I'm Jeff Smallwood. I'm an engineer at Pex River. I just signed up and did the training too through St. Mary's, but I expect I will probably mediate with Calvert some as well. And we'll pass it to, let's try Malcolm again.
Oh, again?
I think you missed your first go around, Malcolm.
Oh, yeah, the thing wouldn't connect for some reason. I'm Malcolm. I'm in the this first mediated class, and I'll be working in Calvert. Thank you, Jeff.
Who goes next, Malcolm?
Oh, I don't know.
Who
Has
hasn't
Dusty
gone yet?
has Dusty done it?
Yeah, Joe Carr hasn't done it. Joe Carr.
Okay, I don't see Joe. Okay, Joe Carr.
Love you. Hi, I'm Joe Carr.
Oh, there he is.
I'm a mediator from Calvert County, and I've been mediating since 2012. And I'll pass it on to Antoine. I saw him earlier.
Thanks a lot, Joe.
Antoine.
Yes, my name is Antoine White, and I'm very new to this mediation thing. So I'm excited about learning about what mediate. No, I'm joking. My name is Antoine White. I've been mediating for a couple of years, and I mediate with Calvert.
Who's next, Antoine?
Willetta hasn't gone.
Okay, how about Willetta?
Hi, I'm Willetta Love. I'm with the Calvert Center. And remind me, Sherry, what year did I come in? It's been a while.
You were before me, so I don't know. Sometimes
so it's been that long.
12.
Yeah, so it's been, because I was thinking 2010.
That's probably about right.
Yeah, and it's great to see everybody, and it's great being a part of this group, which allows someone like me to come in and out depending on life circumstances. So I appreciate being here today.
Great, thanks. Let's see, Tara.
Hey, I'm Tara Pugliati. I'm with Calvert. Been there, I think 5 or 6 years. Can't remember. It feels like it's been so long.
Thanks. And let's see, has Teresa gone yet?
Hi, I'm Teresa. I live in Charles County, but I'll be working with the center in St. Mary's County. And I'm a part of the cohort that's still going through training.
Let's see, who else? Rich?
Hi, I'm Rich Bone. I'm with St. Mary's County. I've mediated for a long time, but with the center, I've been there about 4 years.
Let's see.
Patricia gone?
Yeah, how about Patricia?
Hi, my name is Patricia, and I'm a mediator in training, and I'll be mediating in Calvert County.
Great. Has John gone yet? John W?
Nope.
Hello, I'm John Wharton, and I'm a mediator in training in St. Mary's County.
Okay, who did we miss?
I think
Everybody
that's
go?
everybody.
All right, awesome. So Mia is going to join us later. She's in another Zoom meeting right now, but she hopes to be on by 7. So today we're going to talk briefly about note-taking and then get into agreement writing. So all of you experienced mediators, feel free to chime in if you've got anything to add, and we'll get right into it. So I'll turn it over to Dusty and John, who are our note writing experts.
Well, I'll turn it over to Dusty, who's
Unmute yourself, Dusty.
Thanks for the reminder. So, okay, so why do we take notes? What's most useful about notes? Anybody got any ideas? Do we take notes?
So we can remember.
Yeah, that's good, Malcolm, remember. And do we, in terms of supporting like reflections or summaries, where would they be most important, or agreement writing?
All of the above.
All the above. That's probably not bad, especially since taking notes sometimes helps us focus too. But in general, you know, the note taking is not that helpful for reflections, because giving good reflections is about really just being in the moment and being able to respond to what the folks are saying, just as they're in the midst of their conversation. So the more, while that might be beneficial sometimes, it's the thing that notes are more helpful for is when we get to where we want to do a summary for folks. And so keeping in mind that that's where you really make your money on helping yourself construct a summary. That's why we try to stack our notes by individual issues or topics, however you can think about it more clearly. If you remember that page from the manual in the training for the recent group, the ISCT instructors talk about bubbles and legs. So a bubble in the middle of the page is a theme, could be car payments, could be, you know, the fence between the two houses, could be, you know, dirty clothes on the floor. Whatever people are talking about, we identify that kind of for ourselves and just start chunking things on either side of that. Those are the legs, if you think about the bubble and then the legs. So you do that, and hopefully what you can do then is, after a while in the conversation, you can identify perhaps 2 or 3 themes. And at that point, you'll be able to do if it's appropriate, you'll be able to ask if it might help them to go over and review what they've been talking about. They've got quite a bit on the table. And then you go each one theme by theme and what each person said. And it's important to do, you know, pay just as much attention to disagreement, because that's where the work is, as to anything they agree on. So again, down the center of the page with themes, and on either side, typically, you know, what party A says, what party B says that seems important, that seems to show, you know, some heat or some sense of frustration, or some, you know, opening up to seeing more possibilities, whatever it happens to be that supports. In the meantime, you're doing reflections, you know, and the fact that you've done a reflection is probably a good indication that, you know, it's something that may be helpful to stack up on those notes too. So John, did you want to talk about the note taking too? I was going to have something handy to show an old set of notes, but I didn't get a chance to do that before we started.
No, I think it's one of these things that you've got to do. And in the training, the challenge that I felt that most of the trainees had were identifying the themes. But when you think about it, first of all, if you've been as you mediate certain types of cases, you automatically kind of understand the general lay of the land. If it's a landlord-tenant case, there's rent and there's notice to leave, and there's damages and so on. And in the parenting case, there's a regular schedule, there's making decisions, there's child support, whatever. The fact is you'll get more and more comfortable as you with the general range of themes from which people will pick their actual issues from. So those are the issues, and the thing is it makes for a very easy visual of what has been discussed down the center of the page. And when a topic comes up, I just write it down right away, and they may not go back to it, or they may go back to it 2 sessions later. And so keeping in mind it's an outstanding record. And the first point of time of using that record, typically in a mediation session, is when you offer a summary, as Dusty just said, after a fair amount of material has been covered. And so it's a matter of doing. These are skills. There's nothing academically sophisticated about it. It's just getting comfortable to do it while everything else is going on around you, of course. People are talking, arguing back and forth, there are reflections. And what's one of the advantages of having a co-mediator? It's not unreasonable, especially if you're starting out, to say, look, would you focus on reflections, and we'll each do reflections, but would you focus more on that, and I'll focus on the structure for a summary. So you can do that with your mediator and a co-mediator, and that takes a lot of the pressure off you.
A couple of things just to underline what John said. As people come back, if we're following participants through a session, as we are trying to do, hopefully, so they'll talk about, the fence on the property line first, and then they'll go about the overhanging branches. And then 15 minutes later, they're going to come back to the fence probably. So if they do that, you can just lump those up in the upper where you kept the fence notes before. You don't go chronologically down the page, in order of everything they said. You kind of take those notes by issue, and they'll, there's a lot of things that people will talk about. They'll leave, they'll come back, they'll talk some more, they'll leave, they'll talk about something completely different, a third issue. So it just helps you stack by topic or by theme. The other thing I was going to say is that you don't have to stress too much about what you label the theme. If they're talking about the fence on the property line, if you pick it to say, well, first you were talking about the property line, and the reason it's a problem is it's a fence, or that's one thing. If you say, well, you were talking about the fence, and that's troubling because you're not sure of the property line, it's all the same group of issues. So don't worry about whatever the noun you pick or the nouns you pick to label it. That's okay. If it makes sense to you, that's good. How the notes look, other than hopefully in the general category of themes and what he said, what she said, everybody's notes will look a little bit different. Some are neat and orderly, some are all over the place. But again, the primary point is to try to keep them by themes and try to pay attention then to what each person said. So, okay.
So what we're going to do, so what we're going to do is we're going to have a short role play. Sherry and I will do a role play, and Dusty and Vicky will mediate, and you all will be mediating right along with them, not intervening or reflecting, but taking notes and being prepared in case after about 15, 20 minutes, be prepared to be called on to give a summary. Okay,
So if anybody needs to, grab some paper and something to write with, because we'd like you all to try taking notes during this role play.
and then,
And the role play is going to be a straight community mediation. And all we know about it is that it has something to do with a landlord and a tenant who have decided to come in. They're having some sort of a disagreement, and they're decided to come into community mediation and try to get some help talking it over themselves rather than starting at the district court or something. So this would happen often in the community or in the CMC office or down at the Friends Meeting House in Calvert or wherever in St. Mary's. So these are typical bread and butter community mediations.
and for efficiency, we're going to skip the opening statement, consent to mediate form, and begin just as if we've done that. We've signed the consent form. We've had all our questions answered, and it gives me a chance to complain to my landlord, who was you were my landlord for 2 years now, and I thought we were on great terms, and I thought we left on good terms.
John, are you starting now?
Oh, yeah.
Yeah.
I'm always into it.
John, are you starting the mediation?
Yes.
Okay, okay, wait a minute. Let Dusty and I just do a little tiny welcome. How about everybody else turn off your video, so just the role players and the mediators will be on? That will be very helpful. Excellent. Okay. Okay, well, welcome to mediation. My name's Vicki. I'm one of your mediators. Dusty, you'll see in another little tile here is your other one. What are your names?
I'm Sherry Tardio.
Sherry, thank you. Is it okay to call you is it okay to call you first name?
Certainly, yes.
Okay, and what is your name, sir?
Bill.
Bill?
Just call me Bill. Just call me Bill.
Just call you Bill. Okay, and again, we're Vicki and Dusty. Thank you for being here. We don't know why you're here today, but that's not important because you will be making all the decisions. And it's Dusty and my role to just support your conversation. So you decide what's important to talk about, and you decide whether there's any sort of, agreement that comes out of this or not. Where would you like to begin?
Yeah, well, I'm sorry I started talking because I'm so upset about the situation and cut you off, Miss Vicki. But Sherry, it's just unfair, totally unreasonable that after 2 years of what I felt was great relationship, you as the landlord, me as the tenant, have left. I thought we left on good terms, and then you hit me with a claim on my security deposit, and then you hit me with a fee for for the fact that you took an extra couple of months to rent the apartment. And as far as I'm concerned, I'm serious. I'm going to file if I don't get this thing resolved.
I'm sorry.
No.
So Bill, you're saying that you're really upset that this is very unfair to you, that the two of you had a pretty good relationship as landlord-tenant, and now you're just really upset and surprised that a claim is on your security deposit as well as fees, did you say? And that you feel like this is going to court.
Well, it should. I mean,
It should.
except I think this is so my situation is so understandable and reasonable that you as mediators will appreciate exactly where I'm coming from. Yeah.
So you're thinking that this is really understandable, Bill, and that we'll kind of get it. And again, it's not so important that Vicki and I get it. This is your opportunity for you and Sherry to talk over this, and that the two of you can get clear on exactly what's going on here.
Okay.
So can I say something now?
Yeah.
So
you need to get in here, Sherry.
Yeah. So I mean, Bill, Bill acts like he's so surprised that he's gotten these fees, but this should be absolutely no surprise. He didn't honor the contract that we had. You know, I had to withhold his security deposit to cover a month's rent because he did not give 30 days notice before he left. And he knows that I require 30 days written notice. He did not give that. He just left on April 30th. And I was not able to rent that apartment again until the middle of June. So I lost an entire month there. That's why I kept that security deposit. And that should be absolutely no surprise. Bill, you signed the contract. You should know that.
We're on a month-to-month basis. I gave you verbal notice. Unless you're going to deny that, the end of March, 30 days in advance, told you that I had a job change, told you that I would be out the end of April, and you acknowledged it verbally. And as far as I'm concerned, we met the requirements of the contract. And I don't know where we've been on a month-to-month basis in the standard rental agreement, and I gave you notice. I told you exactly.
Month-to-month has nothing to do with it, Bill. The contract that you signed requires 30 days written notice. So, you know, even if you told me that that's fine, you still needed to follow up with the written notice, which you did not do.
So you're just taking advantage of that technicality when you knew all along for a full month that I was going to be leaving.
It's not a technicality. What if you had decided not to leave? I mean, you could have said, I'm not leaving, and because you hadn't given notice, I couldn't have given that apartment to somebody else. So
and I offered, and you took advantage of I offered that you could show the apartment. All I asked for you to do is to give me a phone call the day before, and you did show it on occasion. In some cases I wasn't even there. So you were proceeding as if I was leaving.
Well, you didn't follow the contract, and regardless, when I checked the apartment out after you left, there was $600 worth of damage to the wood flooring. Now, that's why I kept your damage security deposit. The drain was leaking under the sink, and it totally damaged the wood down there. I had to get it all replaced. That was $600. And then in addition to that, I never got your keys back. So, you know, that's another $50. So I could actually be charging you more than I am. I'm only asking for a month's rent and the $500 damage security deposit. I could actually be asking for more than that. So I think I'm being very reasonable.
Let's be clear about this leak. The plumbing is your responsibility as a landlord. When I found this leak, and I don't know how long it'd been leaking before that, when I found this leak under the sink, I called and spoke to your husband and told him about it. And then eventually you sent a repairman, but it took a couple of weeks for the repairman to get there. So you're looking to me to charge me for something that's basically the responsibility of the landlord. And I grant you, when when we did a home inspection at the start of the rent, nobody noticed that. So if it was leaking then, but when I found it leaking, as soon as I saw it, I spoke to your husband, and it took you 2 weeks to get a plumber there. I can't be responsible for that. That's
Well,
your
again,
responsibility.
Again, Bill, your contract says that you contact me if there are any issues with the apartment, any damages, anything like that. Calling my husband, he completely forgot. He didn't tell
Well, he
me
answered
until
the-
over a week later. You need to do things the way it is written in the contract, not the way you think it's okay. Once again,
That's
you
just
didn't follow the
nitty-
procedure.
A nitty-gritty, picky excuse for something that you know. I called your house. I get your husband. He said he would
My
let you know.
husband is not the landlord.
But excuse me, obviously you did get the message because eventually a plumber got there. It took 2 weeks.
It took 2 weeks because I didn't get the message for over a week. Whereas if you
Well-
had called and spoken to me directly, I would have had the plumber there right away. So again, you're not following what is written procedure that you knew well about, but you decided that it was good enough, just like you decided it was good enough to give verbal notice without the written notice. You decided it was good enough to let my husband know. Well, you know, he doesn't remember where his head is if it's not on his shoulders. I mean, how could I fix it when I didn't even hear about it?
Look, Sherry, I can't be responsible for your husband keeping his head on his shoulders. But I'm looking at your bill that you sent me, and you even charge me $50 for lost keys. Now, when we left, you weren't around. I don't know what the contract says about that, but we needed to give the keys to you. You weren't there. So we left the keys on the kitchen table and snap locked the door. Now you want to charge us $50 for it. I don't no idea where the keys went if you're saying you didn't get them, but I can tell you for sure I have no use for them, and we left them and walked out.
Well, first of all, Bill, as I said before, I'm not charging you the $50 for the keys. I said I could have. I'm charging you the $500 damage security deposit I'm not giving back, and I'm not giving back your rental deposit. I could have charged you an extra $100 for that $600 repair, and I could have charged you the extra $50 for the keys. I'm letting that go because, you know, before this, you were a good tenant, and I'm not trying to nickel and dime you. I'm just keeping the security deposit.
I'm sorry, Sherry. I'm the same good tenant, and you're not the same good landlord.
Oh, please.
So let's do it. You're taking advantage of. And
so I mean, Dusty and Vicky, I mean, if we take this to court and I've got a copy of the contract, he didn't follow it. The judge is going to find in my favor, right?
So you're wondering on how this might play out if you actually took it to the district court, and you feel like you've got a really strong case and that you can take the contract and demonstrate what that says.
Yeah. I mean, he might think it's nitty gritty or whatever he said, but that's what the contract is. You can't just change it because you want to do it differently.
So you can't just change what the contract says because you want to do it differently. And Bill, you feel different about a lot of this stuff. I wonder, you've talked about actually quite a lot in a fairly short period of time. You've actually covered 3 or 4 issues. Would it be helpful at all for Vic and I to go through and do, kind of review what you've got on the table so far?
Sure.
And that's, I think, Sherry, you nodded your head, and Bill, you said that'd be okay. That'd be fine.
Yeah.
Okay. So I'm wondering if any, we've got a number of other mediators that are, monitoring today. So I'm wondering if a couple of you would like to take a crack at doing a summary for Sherry and Bill, just Bill.
Does anyone want to try to do a summary of what they've talked about so far?
I'll give it a shot.
Okay, John. You can put your video back on for
Okay,
us.
I have.
Thank you.
Bill, you clearly feel that it's unfair that your $500 security deposit is being held along with a 1 month fee for a 1 month vacancy. That you feel that there was this is unfair because you had a month-to-month rental agreement and that you gave verbal notice that you had a job change, and that that you feel that having to get written notice was would be a technicality, and that that the rental unit was showed during that time after you gave written notice, and that you feel that being charged your security deposit for any damages was the damage was a result of a plumbing issue that was not your responsibility, and that there was also a delay in addressing the plumbing issue. Sherry, you feel that the contract was not honored, that the contract required a written 30-day notice on giving the month-to-month agreement, and that there was $600 worth of damage to the floor from the leaky plumbing, and that you feel that you're being reasonable about this issue, and that you needed to be notified personally of the plumbing issue.
Okay, thank you, John. Let me say just a little quick debrief on that. You did a really nice job on sweeping up on the kind of the major issues that they talked about. The only thing I would say is that better practice, and what we generally like to encourage people to do, is do it each issue what John has to say, what Bill has to say, and what Sherry has to say, emphasizing what they agree on, what they don't agree on. And so then you do that and you move. So like in your case, you move for security deposit first, you name it. Bill, here's what you were saying. Sherry, here's what you're saying. And then move to the next issue, like the whether the notice was given or not. Bill, you said ABC, Sherry, you said DEF, So just better to go issue by issue, but within each issue, talk about first what one person has to say and then the other, okay?
Thank you.
Good, sure, thank you. Who else would like to give it a shot?
Kudos to John for being brave enough to step up and try it.
Yeah, thank you very much, John. And you did do a good job of tracking what they felt about the issues.
I'll go.
So I think I hear Emma saying she'd like to try.
So it sounds as if both of you are upset about quite a few things. First kind of issue is the loss of money as far as the deposit and the fees go. Bill, you're feeling that this is unreasonable and unfair, that you should get that money back because you've been a very good tenant and you had a very positive relationship, and that you feel that this is an unfair thing that's happening. Where Sherry, you feel that the deposit that you're keeping is reasonable, and that you could be charging more, but you're trying to show grace towards him because of that positive relationship that you did have. And these fees, more specifically, about the plumber, Bill, you feel that you communicated effectively that you needed a plumber when you called Sherry's husband. And Sherry, you feel that Bill should have called you directly and given you more time to get that problem fixed, so that the wood flooring didn't have the $600 of damage. Whereas Bill, I think you feel, as far as that wood damage, you don't feel that it is necessarily your fault, because you did give that notice when you called to her home and to her cell phone, and it was somebody else that answered. You gave that notice even though it was not Sherry directly who answered. And so you feel that you shouldn't have your charge kept. As far as I think there's another large concern about the concern over a contract breaking. Sherry, you feel that Bill has kind of pushed your contract a little bit that he signed, as far as not contacting you, not giving your 30-day written notice. And because of these things, and because there was no notice before he left on April 30th, you feel very upset that this contract was not followed. Whereas Bill, you feel that you did give that 30-day notice, even though it was verbal and not written. You feel that this verbal notice was enough because Sherry was showing the apartment to other people during that month after you had given that verbal contact. And so I think that you feel that that was enough of a contact. And so I think that you're both kind of feeling that this positive relationship has kind of soured. That's it.
Yeah, that's right. She showed the apartment. She knew it was up for rent. She's just trying to get an excuse to make an extra month's rent.
That's insulting.
Feel like that's insulting, Sherry.
Yeah, that's very insulting. I'm not just trying to take
I think
money.
we should move on, because this segment is, we've had two summaries.
Do we want to offer a little bit of feedback to Emma? Emma, nice job. I love that you got in the feelings. That was really good, about the feelings of being unfair. Yeah, let's see your notes. Let's see. She took a lot. Look at this. Very good. On one side and on the other side.
Yeah, I think that what helped me the most was taking down the notes of everything and then finding the overriding concerns: the losing money, the contract breaking, and the lack of communication.
So those were your themes. Dusty, let's see your notes. Can you hold them up?
Let's see.
Yeah, there you go. See, the themes are right down the center. And then what each person said about that particular topic is on the sides of it, the legs.
Yeah.
Can you see?
Let me add something to what Dusty's done. He doesn't draw a line down the middle of the page. Your clients will see that, and it implicitly creates divide. What Dusty has got has a sense of unity by having the main themes up the middle and then comments on each side.
Yeah, excellent point. Dusty, do you want to just give your summary for an example?
Sure. So, Bill and Sherry, it's only been 10 or 15 minutes, but you've covered a lot of territory. So here we go. You said you were okay with that. The first thing I heard you talking about was the security deposit. And Sherry, you said, or Bill, first you started out, you said, it seems really unfair that Sherry wants to keep that deposit, that you've had a really good relationship as landlord and tenant over a period of time, and you're very upset about that. Sherry, you said, well, yeah, fine, but why is Bill even surprised about this? He didn't honor the contract, and a big deal about that is, I forget about the security deposit, what the issue was in that exactly. I guess that wasn't the notice, because the next issue is notice. Sherry, you said, you kept 1 month's rent back, which is exactly what you're really authorized to do and supposed to do. It's 30 days, supposed to be 30 days, and it's supposed to be in writing, this notice. And so Bill apparently left on April 30th, and you weren't able to rent the apartment till June again. He said this is not a technicality. It's, people change their mind all the time. And if you don't have the written notice, what are you supposed to do when they kind of just come up later on and say, well, no, I'm going to stay actually. Bill, you said, hey, it's not like that. You've been on a month-to-month lease all the time. It's been much less formal than like a multi-month lease or something. You did give verbal notice that you had a job change and you were going to have to move, and that was to Sherry. You said you told her that you would be out at the end of April, and you feel like Sherry is, in this case, is taking advantage of you, that you even offered her, after you talked about the fact that you intended to leave, you'd offered it that she could share it, while you were still in there, and she did, at least on a couple of occasions. So it's pretty clear to you that Sherry knew and understood that you intended to leave and were going to leave. Next issue is damage to the floor in the apartment. Sherry said you're keeping the damage deposit, that's $600, because the floor had a lot of water damage. It was really wet. By the time you got the notice of it, it was clearly needed to be worked on. It was a plumbing issue. It was at the core of it. Bill, you said, well, yeah, but you told Sherry's husband about it. And even after that, it took 2 weeks to have somebody come out and look at it. You can't be responsible when you told him. You think that's just being nitpicky, really with you. And Sherry said, well, not so fast. There's a reason the contract says that Bill was to contact you about any issues with the apartment. Your husband isn't really the landlord. He's, likely to lose track or forget. And in fact, he said that's what happened here. You didn't find out for another week because you hadn't been notified. And then it took a second week to get a plumber out there. So that's what caused all the damage. And, on top of all that, there was, a business of the key return that Bill, you said you left it on the table. Sherry, you said, I don't know, if somehow you didn't get
He's
it.
frozen.
Who is frozen? Am I frozen?
Yeah. Well,
No.
oh, not.
No.
Oh, okay, good. Sorry.
Okay. So anyway, the key, Sherry, you said it really doesn't matter. You're not charging them for that anyway. You're just going for the damage deposit and the rental deposit. So where would you like to go with that? Do you want to talk more about any of those specific things, or you want to go to something else? What do you want to do at this point? And we're not really going to do that.
I'm waiting to hear from Sherry how she's going to settle this thing in a reasonable way.
So you'd like to settle this thing in a reasonable way, Bill, and you'd really like to hear from Sherry at this point.
Yeah, she has to move from unreasonable to reasonable.
When you insult me, Bill, it really is not making me feel very kindly toward you, but I don't want to have the hassle of going to court.
Okay,
If we
so
can work this out ourselves, I'd prefer.
we're supposed to stop this mediation, interrupt this case, and we're going to continue it in a little bit.
Okay.
So now what we want to do is talk about moving as mediators, working with clients, moving towards agreement. The human tendency of a mediator, especially a new mediator, when that mediator hears a piece of agreement, they tend to say, well, we're going to get an agreement, and they grab these things. And so the process of working with your clients to help them, if they're willing to move to an agreement, is much more subtle. And we have a page from a manual from one of our outstanding teachers that Sherry's going to go through, and that's what, and then we're going to continue with this mediation, and Dusty and Vicky will see if there's a chance that if they twist Sherry's arm, she'll agree to something reasonable. Okay, so I'm going to screen share with everybody. This comes from a manual by Louise Fifth-Senft. She's an outstanding, internationally known trainer and mediator in our transformative framework, and has probably taught at least 5 of our 5 20-hour sessions for us over the years. So Sherry, you're going to go through that, or
Sure.
Dusty, Vicky, whatever. Let's
Yeah,
put it up
I'll
on
be
the
glad
screen.
to. So this is just sort of talking about how you mediate when you start hearing some things that they agree on, because as John said, the tendency for a lot of us is to think, great, they have an agreement, mediation's over, let's write it up. And that's not how it goes. We actually continue that transformative process all the way through the agreement writing, which means that you may start writing up an agreement and then hit a bump in the road, and then you go back to reflecting and summarizing and things like that. It's always a work in progress. So basically, in terms of the agreements, the first thing is that the participants determine whether or not they want anything in writing. Now, if you're, mediating in district court or something like that, yeah, if they want their case, to the judge to do something with their case, there has to be something in writing. But when you're doing the community mediation cases that are just ones that aren't court referred, they may not want an agreement in writing. They may just say, a handshake's fine or whatever it is. So the first thing is to determine whether they even want any of this written down. Don't make the assumption that just because they're listing points of agreement, you need to start writing up a formal agreement for them. It's up to them whether they want to do that or not. Let's see, the agreement writing is part of the process of mediation, like I said. So the agreement writing is a very interactive conversational process, just like the mediation itself is. So it's not like all of a sudden the mediators take over. As a matter of fact, you can ask whether one of them wants to write up the agreement, or should the mediators write up the agreement, or if there's an attorney there, perhaps the attorney wants to write up the agreement. So it's not even necessary that the mediators be the ones to write it up, although usually people prefer that the mediators do it, but that's not a given. So, if somebody wants to write it and the other person's okay with that, then that's fine too. They determine what they want in their agreement. So, it may be that they just want the points where there's actionable items written in there, or, they may want more than that. For example, if somebody apologizes, that may be very significant, and they may want that written up in their agreement. So the 3 things actually that I look for to help me remember what is possible to put in an agreement are the 3 A's. This is something we use in restorative justice as well, which is affirmations, apologies, and actions. So, you want to look for if somebody is affirming the other person, that would be that recognition piece. If they have something positive to say about the other person, or, that even just the fact that the two of them came to an agreement, that's an affirmation. If there's an apology, that might be important for them to note or not. And then any actions that need to be taken. So that sort of helps me keep in mind what types of things I might put in the agreement. And again, it's up to them whether they want that in there or not. The decision-making is again up to them, and it continues throughout the agreement writing process, like I said. So what to write, who writes it, when to start writing it, all of that sort of thing. And then, whether or not, if they have an agreement, whether they want to sign it that day, whether they want to bring it home and look it over and think about it, whether they want an attorney to review it, that's all open as well. So just because you write an agreement doesn't necessarily mean that they're going to sign it that day. They may or they may not. Sometimes people like to see things in writing during the mediation as well. We do have in the office, we have, big pads of paper that if people want to see the things they've talked about, you can write stuff like that down if they come up with ideas that they want written down. So you can record anytime during the mediation. It doesn't necessarily have to be just at the end. Let's see. So all significant accomplishments should be recorded. That's what I said before. So think about the 3 A's. Again, affirmations, apologies, and actions. The 3 things that might go into the agreement. And then lastly, as whoever's writing the agreement is going to be constantly checking in with the parties. So you may write a sentence or two and then read it back and say, okay, how does that sound? And then they can always change it. So, you want their words as much as possible. We'll get into this more, but you're going to avoid legalese. You're going to use their words so that really anybody that picked up this agreement and read it would understand what's going to happen. So any questions about any of that? Okay.
Could we get a copy of this sheet,
Yeah, I could send that out.
please? Thank you.
Yeah, let me make a note to send that out.
You can all turn your videos back on.
Well, I think what we're going to do now is actually go back to the role play with the two, with our star mediators twisting Sherry's arm and get her to do a reasonable resolution.
You hope. You
Okay.
hope.
Okay.
So the last thing you said, Bill, was that you would really like to come up with some sort of a reasonable resolution about this, and that you would like to hear from Sherry about what that might look like. Sherry, you said that before you had said that your intention is not to nickel and dime Bill, but you said that I can't remember your exact words, but that he's not making it easy on you to think kindly of him.
Yeah, absolutely. But, I can be a bigger person. I came to the mediation because I'm willing to negotiate, because I would really rather not have to take the day off and go into court and all of that. So, actually, I thought what I was asking for, which was $1,400, was reasonable. I dropped $100 off of the cost of repairing the wood floor, and I dropped the $50 for the keys. But apparently, Bill doesn't think that's reasonable. So, I would like to know from Bill what you think is reasonable.
Well, I told you I can't accept the responsibility for a leak that is the responsibility of the landlord, and the fact that it took 2 weeks or to get the plumber.
Well,
And I realize that you, you know, can't rely on your husband, you're now saying to me, to let you know that I called him and complained about this concern. And I don't know how long that leak has been going, since the damage to the floor is a lot more serious, I think, I'm no expert, than just simply the 2 weeks. I think that this has been a problem possibly from a prior tenant. I just don't know.
oh, no. Now you're saying you're not responsible at all. That's just wrong. That's just wrong. You've been there for 2 years, Bill. I think if there had been a leak from a prior tenant, you would have discovered it well before when it happened. So the leak obviously happened sometimes during your stay there.
So that's just not
Right.
acceptable.
As soon as I saw it, I called.
Well, I understand.
Okay,
I understand
and
you
again,
called. I understand you called, but once again, you disregarded the process. Now, I'm willing to bend a little bit because obviously I guess there was some miscommunication about what had to be done. But you know, I'm not willing to say you don't have any part in this at all, Bill.
You're willing to bend, Sherry, on this, but you need for Bill to take some sort of responsibility for this. He's been in the unit for 2 years, and that he didn't go through the appropriate process to notify you about the leak. Bill, you said that, you know, you did tell Sherry's husband about it, and that it wasn't your fault that no one went out to do anything about the leak until, weeks later. But
yeah,
Sherry,
that's right. That's right.
Sherry, and you've said many times before that process was really, really important to you, that the process was to tell you and not your husband, that,
right.
That you're the one that's responsible for it, and that has been in writing in the contract, that you are the person to be notified.
Well, and you can see why the process is important, so that things like this don't happen. That's why we have that process written down with a written notice and with contacting me directly, because I don't want these miscommunications and non-communications to happen.
Okay.
And it's not important just because it's important. It's important because it prevents things like this from happening.
It prevents things like this from happening.
So you're sitting on $1,400 of mine. Actually, you're sitting on $500, and you want $600 more, or what is it? $700. What is it? You said 1,400. You better explain that. I guess it was 1 month's rent of 900.
Yeah. Exactly. So 1 month's rent is 900, and then I'm keeping the damaged security deposit, which is 500, so 1,400. Bill, I'm willing to split things with you, because like I said, we had a good relationship, and I would like to end this on at least fairly good terms. So, the damage to the floor was $600. I'm willing to split that with you 50-50, 300. And
split the rent. You were able to show the apartment during the month of March, or during the month of April, rather.
so you're saying that you would be willing to pay me $450?
You've already got 500 of mine.
All right. So
yeah.
See,
I'm open to that.
Okay,
I'm open to closing this thing out and I'll pay you an additional $400. And I need, yeah, I need a little time to pay, at least a couple of months.
Okay, so Bill, I kept your $900. I haven't returned that to you.
So you owe me,
So
you owe me two.
What I'm saying, Bill, is that I'm willing to split the month's rent with you 50-50. So I will return $450 of your security deposit. I'm also willing to split the damaged floor with you. It costs $600. So I'm willing to split that with you, $300. So I will give you back then $200 of your damage security deposit.
Okay.
Will that work for you?
Doesn't make me happy. Don't feel fair. But
That.
Pardon? I'm sorry, I missed that. What was that, Bill?
I just don't think I can live with it, but I don't think it's fair.
Oh, you
Right.
can live with that, but you still don't think that that's fair.
I think that is more than fair, Bill. I mean, if we went to court, I would show them the contract. You were clearly in violation of the contract and I'd get the entire $1,400. I'm willing to give you back $650 because we'll split the differences because of the communications. I think that's more than fair.
So Sherry, you think that's more than fair because you're giving Bill $650 back. You said that if you were to go to court, you'd be asking for the entire amount and
plus court costs.
Pardon me?
Plus court costs.
Plus court costs. And so you feel like this is just more than being fair.
Yeah, definitely.
So Sherry, your final offer that, I'm sorry, can I just ask you to affirm? You said your offer was to split the damage deposit. The damage deposit is 600. So you want to you would give 300 of that back. Is that correct?
No. So I'm talking about the damage costs, not the deposit. So it was $600 to repair it.
Right.
The damage security deposit was $500. So I will give him back $200 of that, meaning that he paid $300.
Okay.
So basically we're settling this whole thing. It was $1,400. We're basically splitting it in half to $700. You've got $500 of my,
So I'm going to give you back, Bill, $650. So that's half of the rent, $450, and then $200 of the damage deposit.
That's half of the rent and 250, did you say?
200 of the damage deposit.
And 200 of the damage deposit.
Right.
And that totals $650.
Right.
That you are giving back to Bill.
I just because I want to avoid the hassle of court, I don't want this hanging over my head. So if Bill will accept $650, then I'm willing to do that.
You're willing to do that. And Sherry, also you said before that you do want to avoid going to court, and you would like to try to maintain some sort of relationship because you had a good relationship in the past, that you're willing to do this just to be able to preserve some of that.
Yeah, I really desire to have no ongoing relationship with Bill now, but I would like to end our relationship on decent terms.
You would like to end it on decent terms.
Yeah.
Yeah, even though you don't desire any relationship going forward, but just to end this one on decent terms.
Would you guys write it up? Would you guys write it up, please?
Bill, you'd like to have us write it out.
As far as I'm concerned, write it up, and I don't think you need to break it down in details. I think all you need to do is to say that we'll settle all issues. You can list the issues and say Sherry's going to give me a check for whatever.
$650. So you're saying that you'd like us to write up the agreement, but you're saying that it's not necessary to break it down, saying that she's giving you.
I see no reason to break it down.
Mm-hmm.
So you just want to document the action items remaining from your agreement, if you will.
Exactly. That's just fine.
That's fine, as long as everybody's clear on what it is we're doing and is okay with this. I don't want to have to revisit this again.
Okay, so this is okay with you, Sherry, as long as it's clear on exactly what this is.
Yes.
So so would you feel like it that you need more clarity in the agreement or not? I mean, is it clear enough just to say that you are, you know, that you're giving Bill $650 back, and it doesn't, and we don't need to say exactly where that's coming from or why that's coming?
I mean, as long as it's written in there that this closes it out, we're done. And neither of us owes anything further.
Okay, gotcha.
That's fine with me. That's fine with me.
Okay, good. Thank you.
So can we maybe break and let me go through the this nice seven of kind of criteria for writing agreements, what a written agreement might look like structurally in general, and then continue?
Sure.
Can I do that?
Sure.
Okay. So
do you need to share?
I'm going to share screen with you. And so, come on. Can you all read that?
Yes.
So here's a general outline that whether it's a parenting plan or a landlord-tenant case, the first thing to do in a writing agreement is to clearly state who are the parties. And in this case, it would be Sherry Tardio, who is the owner and landlord and owner of the single family residence at such and such an address. And Bill Roberts, the tenant at that address. So it's clear who we are. So if we were parents, the opening sentences or paragraphs may be necessary to describe who are we? Who are the clients? And the second thing is to outline in general the central issues of the agreement. And in this case, agreement is to resolve an issue concerning, and you could list them, concerning security deposit and notice and so on. And that in resolving these issues, the parties agree as follows. And then you go ahead and describe what you're agreeing to. You list the topics in a logical order, best characterize the separate issues. In this case, Sherry and I kind of agreed to condense everything. But if it's two neighbors and they've got tasks to do with each other, or if it's parenting plan, you may have 5 or 10 different issues, different topic areas. You organize them in a logical way. I comment that often we do, as Vicki mentioned, we do short-term summaries, if you will, between sessions, if asked, or even during a session by putting things on the board. And so, but those are the basic structures. Reviewing the agreement either with the parties if they're going to sign it, if they want to take it to an attorney. We're just recognizing there's a review process, and the clients may want to lay out that review process in the agreement. They may also decide who's going to bring the case, a file to the court if that's the case. So, but the basic structure is who are the parties. They've gathered together to reach an agreement as follows. And then you just bullet and paragraph by paragraph or line, topic by topic, you go through and you write it in a way that any third party who has never been a part of the mediation, never heard a word was said during the mediation, can read the agreement and know exactly what is expected from each party. Okay. Something I would like us to put in agreements, if possible, if you're willing to try to do this and remember it, we typically will write when we draft agreements, we draft the agreements on our stationery. So there's a logo at the top, and anybody seeing the agreement can recognize that this is a work product of our mediation center. If you're using plain paper, I would encourage you to say, in a mediation hosted by the Community Mediation Center of Calvert County, the parties, and then you tell them who everybody is. Sherry Tardio, the owner of the property, and rental property at such and such a site, etc. To have a short phrase acknowledging who we are and we're providing this service is really an important outreach effort. So, any questions about what I just went through?
John, I think you also encourage us to do that with the district court mediations, right?
Absolutely, absolutely.
Mm-hmm.
Oh, absolutely.
So the first sentence in the district court on the district court form would say that in a mediation hosted by the Community Mediation Center of St. Mary's, Community Mediation Center of Calvert County.
Yeah.
Okay.
John, did you want to, if we're using letterhead, should we still say something in the first paragraph?
I would do it. I like it, but we generally don't. It's not nearly as important. And so I don't know that it's, it's pretty obvious we're hosting it. It's our letterhead.
Right.
So it's particularly where you're in the court doing your day of trial, or for some reason you're out just at a church and you're doing a mediation for the center with you add a paper and you write it up and you it's just a short phrase in a mediation hosted by Mediation Center, the parties, and then when you say the parties, you don't have to use the word parties if it's too legal for you, but the parties, and then you put down who they are and what their role is. So that everybody, third party reading that knows exactly who is there. And then, yes, as Sherry said, one of those bullet items can be an apology, and one of those items could be an accommodation, and the other can be how you basically the action items. And the general rule is to have bullets numbered so people can refer back to it, the agreement. And so, but again, going back, we're going to go back to our mediation. Just because it looks like Sherry and I have reached agreement, you never know. Because she's already proven how unreasonable she is. So
Yeah, I didn't hear any apologies from anybody.
If you please take over again and
So-
let's go actually draft the agreement, okay?
Okay, so Dusty, do you want to share screen again with that agreement?
Yeah, if that's good for you, Sherry and Bill, are you ready to get back into that conversation about the agreement?
I'm encouraged.
Sure.
You're encouraged.
Okay, this is one of the mediation agreement forms out of our Community Mediation Center. And I just put your names at the top while we were taking that break there just for a few minutes. So you can see Sherry Tardio and Bill Just, or actually just Bill, but this, I thought that was just more of a nickname based on your Bill Just name there, Bill. So, I just started it off with Sherry Tardio and Bill Just met virtually with mediators from the Community Mediation Center of Calvert County on 19 January 21 to discuss issues resulting from Bill's rental of an apartment from Sherry, his landlord. Does that good capture enough about why you're here this evening?
I think it did. Sherry rents all kinds of apartments. I think it should say which apartment, apartment 2D. And the address.
Rental of an apartment.
At 2D, and what was the address? What is the address?
I've forgotten it.
Sherry?
351 Glendale Road, Prince Frederick.
Humble fingers.
Anyway.
Go to zip.
20678.
Okay, issues resulting from Bill's rental of an apartment 2D at 351 Glendale Road, Prince Frederick, Maryland, 20678, from Sherry, his landlord. They reached an agreement as follows. So, what would you like to address first? Is it the amount of money, Sherry, that you currently hold from Bill's deposits, and then talk about what you're gonna provide back? Is that?
I mean, I just thought we were just going to keep this simple, saying that I would give Bill back $650 from his various deposits, and that closes this case.
So you're going to return $650.
Mm-hmm.
You're standing right. You're standing right. When? After they leave? No. Really? Okay. What time? I don't know. You have something to do later? Yeah, I'll come and see you again. Not too many people. Yeah. Mm-hmm. That's what I said in here because I saw the preacher out there. I was like, okay, I'm just gonna. I mean, I'm doing this, but I thought that was good timing, you know? Yeah. It's like, how many people are out there? Like 7?
So we can hear somebody's conversation. You may want to mute yourself, whoever that is.
Yeah, I think it might be Patricia.
Sherry and Bill, is it important for you to say when and how this might be delivered?
Yeah,
Well, I mean, I'll send Bill a check. Let's see, what's today? The 19th. He'll have it by the end of the month.
So you'll send $650 by check by did you say the end of the month?
Yeah, he'll have it by the end of the month.
Do you really need 2 weeks?
Oh, for Christ's sakes, Bill.
So Bill, you're wondering if you can have it sooner than that, if Sherry really
I
needs
wouldn't be sooner.
2 weeks and Sherry, you're saying really.
Hear you.
Somebody, Patricia, I think you're having an offline conversation. Would you please mute yourself if you're doing that? That's stepping on us here.
She probably can't hear us.
Sherry, can you mute her?
Yeah.
Let's see. Hold on.
That's a Ghanaian recipe, right?
There, she's muted.
There, okay.
Okay, thank you. So, Sherry, you sounded a little frustrated
Bill's being
by
a pain
that.
in my ass again. I'm agreeing to give him $650 and he wants it earlier.
He's being a pain in your ass that you've already agreed to give him the money and he's quibbling about, getting it earlier than you offered.
Yep.
Excuse me, I'm not quibbling.
You're not quibbling, Bill.
I don't know.
I mean, Bill, the mail has been slow. I don't even want to get into the politics of that with you, but the mail has been awful for quite some time now. I don't want to say you're going to get it sooner and then have it be held up in the mail and then, you're going to give me crap about not getting your money when I said you get it.
I give up. Yeah, okay, I give up.
So your concern, Sherry, was that the mail has been a real problem recently, and Bill, you're saying, oh, okay, you understand that you'll give up on that request.
Just get it in the mail within a week and it'll get there eventually.
Good enough. And Sherry, is it important, or for either of you, is it important to talk about, is that a check or a money order, or how is that coming?
I mean, I was just planning on sending a check unless Bill wants to quibble about that too.
A personal check?
Personal check is just fine. Business check, whatever, or personal check is fine.
Personal check is fine.
Yeah, she may pay by personal check if she wishes. And she can mail it to my post office box.
And what is your post office box number, Bill?
Post box 1842, Prince Frederick. Below 678. All right.
And I would like something stated in there that this, once Bill receives the check, he's not going to be asking for any more money back. This ends it.
Okay.
So do you think it's important to have an reassurance from Bill that that's the end of the discussion? When he gets the checks, this is resolved once and for all?
Yes. And it should arrive by the end of the month, not the end of the week.
I'm sorry, thank you.
Sure.
By the end of the month. Excellent. And you're requesting that Bill just acknowledge that this is the final resolution of this, the full and final payment back.
Yes.
Is that something that you both want in the agreement?
Yeah.
So you're good with that, Bill? Okay.
Is there anything else that you can think of that's important for you to put into this agreement?
No, I don't think so.
I'm fine with it. Now, is this a legal document, or, you know, what is this?
Dusty?
So I can't type and think and talk
Okay,
at the
I'm
same
sorry.
time. That's okay.
Sorry,
So
this-
Sherry, you're just concerned that you're wanting to know if this is a legal document. So we're not lawyers, but we do the same thing in the court. And our understanding is that, you know, it's the two of you are going to sign this. And since we're not in a room together, I mean, normally we'd be doing this handwritten. The two of you could walk away with, you'd both sign it and walk away with a copy. I think the way we're doing this right now is we'll have to send this back to our center director, who, you know, she's a little disorganized, but she's okay. She'll try to get it in DocuSign and send it out to you. You know, who knows? We'll hope that it'll go out in a few days. And the two of you will each sign that electronically, send it back to her, and then she'll send the document signed by both of you back to you. And you'll probably get it, hopefully, before you get the check.
Okay, that makes sense.
That makes sense to you? And is that?
So, yeah, I don't know. I think, so, okay. So I do think if I were doing this, I would also put in, you don't have to do it now, but I would put in the same paragraph that we use in all of our consent to mediate about signing in parts. It's a contract to be signed in parts because you're going to use DocuSign. Well, actually, no, never mind. No, DocuSign is great. Okay.
Oh, that's a good point. So John, you would put another paragraph in about that?
No, Dusty's right. If we use DocuSign, we're going to use DocuSign in all our agreements.
Oh, okay.
So we don't, that way the office is handling it. So I would say though, I'm shifting now. I would say though, Bill and Sherry agree that the execution of this document of these tasks as described in this agreement represents a full and final resolution of any issues related to the rental at this property. So that it's clear that there are no more issues about rent. If Sherry were to walk in the apartment the next day and find something else, it's too late. So it should be full and final agreement of all issues related to the rental, or to Bill's rental of the apartment. Anyway. Yeah. Yeah. Yeah.
Yeah, that's good.
Okay. And it's clear any third person can read this and know what it means.
And I think I didn't answer your other question, Sherry, and maybe for both of you that, again, while we're not lawyers, our understanding is that, you know, any document, you know, with enough detail to support your agreement. In other words, what's the amount? How's it going to be passed? Is there a timeline involved? What have you? And signed by both of you is a contract. Now, you know, taking that to court is the start of a process to see if that is as good as any other contract, you know, see what the judge thinks to do about it.
So when we're doing the agreement, we're doing it right along with the participants, just as we did. And rather than asking them, okay, what's the address, or, you know, how's this, you know, in what form, cash, check, money order, how is it going to be paid? Instead of asking those direct questions, we offer it to them. Is that important to you? That, you know, there's something in there about how it's going to be paid or not. So they're always involved. They're always making all of the decisions all along the way. So the agreement writing is still part of the mediation.
Right.
So any other questions or comments on that?
I don't know, it's just it's so subtle, but I think it really, really is important that instead of asking direct questions, that we offer it to them as a decision-making point, you know, a decision.
Right.
So this is, let me say, so this is an agreement with basically one action item. Writing a check, you know, sending a check of a certain amount to bill at a certain address. It's a one action item. If there are more than one action item, I strongly recommend that each action item be a separate numbered paragraph. Skip a line between numbered paragraphs so each one is clear. Again, so it's easier visually to understand what they're agreeing to.
I also always, when writing one of these on the paper forms for either community mediations or court, you know, the like small claims mediations, I always do it double space. And that way, you know, because you often wind up either correcting stuff or going back because they didn't like, you know, they should want to change their mind about how it's written. So it's just a lot easier if you've got room to cross out a, you know, a word or a phrase and then write the replacement above it.
If you're in doubt about the actual language in a particular action item, then verbally say what you're proposing to write before you do all that handwriting. That's another thing. So if there was a second action item, you'd number this action item, and then the second action item, you'd read that out ahead of time. So now, okay, we've got that covered. Now, what about this other item, whatever it was, the key or whatever? And you just, it helps just to state what you're going to write ahead of time to make sure as much as possible that you got it right. So
I just wanted to add that there's a section in, I don't remember if I don't think MIA people have their center handbooks yet, but you will be getting it, and Calvert people have theirs. There is a section on agreement writing in your center handbooks. So, and it's got some examples in there as well. So, you know, please just look those pages over, and, you know, it'll spell out everything we've talked about in terms of writing agreements, and then give you some different samples of what some agreements might look like.
And in St. Mary's, you don't have the handbook, but in the mediator toolkit that I sent out earlier this afternoon, it does have sample agreements, and it also has a little agreement writing 101 cheat sheet as well.
Okay. So we time permitting, and I don't think time permits, we were going to actually do an agreement writing exercise this evening. But we've dumped enough on the table, and so I'd like to talk. I'll just talk with Dusty, Vicky, and Sherry and Mia about how we can get that out. It's particularly important for our newly trained mediators because it's an essential element of your training, and you've had little or no experience doing this. So we'll come up with a proposal, whether we do it just offline with individually with you or whatever, whether it's a TSB or simply just an exercise everyone does on their own and feeds back their homework, so to speak. All right, so, but we do want you to get exercise in writing at least 2 or 3 agreements. And so we'll show you how we have some scenarios, and then you're asked to basically draft the agreement. And the scenario is a scenario of a case with an agreement that they tentatively reached. And your challenge will be to translate that into a lucid agreement. And we'll send it out to everybody, but particularly it's important for a new class to do those. And I think what we'll do is ask you to, when we do that, my thinking is we'll ask you to send them back. We can give you feedback.
Yeah.
But we don't necessarily have to take a TSB for it. Or we can, whatever you guys decide.
And we have a question from John Alfano in chat. And it is, John, you want to just read your question or?
Pardon me,
John Alfano.
Yes.
Yeah.
Okay, finally, I couldn't get the mute off. Yeah, what if we make the settlement document, the language of the settlement document, part of the mediation of the dispute? Don't we run the risk of one party not unknowingly saying, I don't want to have a entire agreement understanding here? And what do we do then?
Well, the point is that if in this case, the landlord-tenant case, if the tenant isn't comfortable with that, then the tenant speaks up. That's exactly right. That's why you have that. That's why that's there. Now this is not uncommon. We do so many day of trial mediations in the district court. So we have a case, and a sentence like that will almost always go into the written agreement, but it would say all the issues related to the above referenced claim or the above referenced case. But if they don't like that sentence, they don't put it in, and then they better have a mediation to discuss. All right, so wait a moment. So you think that this case remains open, and there are new things that you are.
But we just entered into an additional needless dispute with the parties.
No, wait a moment. So look, if there's a potential for a future dispute that derives from this mediation, we better be open to it. We're not interested in closing out cases. We're interested in reaching agreements that everyone understands. So Sherry's understand. Yeah, I mean, that's the point.
I'm not disagreeing with you. All I'm saying is that one party or the other out of ignorance might say, I don't want to have that there. And the other party says, I want it. Now we've opened up a whole new area. Why don't we
That's
just,
right.
And that's a beautiful opportunity for more discussion. We would welcome it.
Yeah, that's
Okay.
that's the nature of this. Look, I don't know if you were here when we started, but my main concern is especially new mediators, but even seasoned mediators have a tendency to grab and hang on to agreements, get that agreement out the door. And yes, you're right. There's a risk by saying, look, guys, in effect, this sense, this means that any issues that you haven't brought up related to this rental, that they're over. that may blow the mediation up. Good. Because Sherry may have another claim that she's got in her back pocket, or I may come, I don't know. It's not so, this case is so simple, but
John, can I jump in for a minute?
Well, let us, yeah, go ahead.
And Joe Carr, I want you to help me out here, because this is about mindset. What is our role to be there? It's not to close it out. We follow them along regardless of what the outcome is, because it is their mediation. And I remember that Joe and I, we were mediating a session where there were a number of issues that came up. And they made some agreements, and we worked on some specific agreements, but we opened up the door by asking them, do they want to follow up later on some of the other things that may not have been resolved for them. We just asked them a question because it's their meeting. They get to decide. And it is challenging because you do want to get, as humans, we want to close this thing out, right? But the type of mediation that we do, the transformative technique, is so different than the other types where you want to get to some type of resolution. That's not our business. We just are there to help people with the conversation, regardless of how it feels, what it looks like. It's really up to them. We just try to help and follow it and support their conversation. And it is a huge mindset shift.
I'm very familiar with this type of mediation.
Yeah.
I just think that we do a disservice to the parties when there is an agreement on the table. They've agreed to the substance, and we're now entangled in a disagreement over what is really a legal issue.
Well, let me just say, John, I've a paragraph or a sentence like that, or a phrase equivalent to that, has been in virtually every hundreds of day of trial mediations that have gone to court, and there's never been a kickback on the part of the clients. So it may be, and so that's just my experience. Okay, so I don't, and those are civil cases that you definitely want. You're pleased as a mediator that it's closed. It's closed. Yeah.
So do any of our, especially our new mediators, I know this could be a lot of information, and remember, you're going to have an experienced mediator there with you. So, you're not going to be on your own writing agreements, right, right at the beginning.
Exactly.
But were there any questions or anything from either the role play or what we've said that, you're wondering about with agreement writing?
I actually was wondering about something. So you mentioned something earlier about having one of the participants, one of the clients, write it themselves. If the client does want to write it themselves, how do you work with being non-partial? So would you have them read it as they write it, or what is the procedure there? Because I would be concerned
that's a good
about
question. So
So
first of all,
I would say, oh, go ahead, John.
Oh no, go ahead.
Okay.
Sorry.
So I would say, we always ask them, would you like us to write it? Or would, I've never had a client want to write it up themselves, or, if one said they do it, the other one doesn't agree to it. So they end up, with the mediators writing it. So I think it would be a pretty rare occurrence. That being said, I'd encourage them to do what we do is, talk through it out loud. What do we want this to say? And sort of work with them on, getting the points written down and then reading it all back, make sure they both agreed to it. That being said, I doubt it's likely to happen.
So, but there is an exception to that. So often if there are attorneys involved in mediation, one of them will offer to write it up. Everybody has to agree to that person writing. So if one person's represented by attorney, the counsel, and the other isn't represented by counsel, and the counsel offers to write it up, then the other party has to decide whether that's okay. I feel a little uncomfortable with that imbalance, but again, unless I felt that there was some kind of intimidation involved, and that's a judgment, I would go along with that, or I would have to deal with that. That's a second order but important consideration. When there are two attorneys involved, which is more often, well, it depends on the case. Some cases there's always one attorney and not on the other side, like relatively low-level employment discrimination cases. The business is usually represented by counsel, and the employee is rarely. But generally speaking, counsel is representing both sides or not at all in our mediations. We have a case coming up involving construction contract with attorneys on each side. We did a property settlement issue, alimony issue, with attorneys on each side. So then they can decide.
A question about the attorneys. How do you kind of work with the language and the legalese there? Do you find that attorneys, when they write it, are they using less accessible language?
Can I say that the handful of times that has been done with us, the attorneys have done a far more sloppy job on the agreement than what you just saw.
Yeah, true.
So I think we're getting kind of far afield from just basic agreement writing, and I wouldn't waste any more time on the legal language here. And I wouldn't, we have other kinds of mediations that attorneys do a wonderful job on. That's not to impugn lawyers, but like in small claims-ish kind of deals, we might have gotten like a one sentence that says Sherry's going to send John a check for $650, and thanks very much. So we're much more careful about at least getting the basics of who, what, when, where, why in there than you might see from other folks working on it.
So I want to be mindful of the time. We're 5 minutes short of ending. So I wanted to, since Mia's with us now, I didn't know if you had any announcements or anything that people needed to know while they're all here. You're muted, Mia.
Thank you, Sherry. And hi, everyone. I'm sorry that I was late, just conflicting meetings this evening. It's so good to see so many faces, like 28 people in a TSB. Like, all right. Like, okay, I'm nerding out on those numbers. Anyway, check your emails. I sent out a semi-lengthy email just updating some new things that we have going on. Just in particular, that mediated toolkit that I talked about that's going to have access to all of the forms and things that you need for mediations and extra things to make you feel more secure with getting started and wrapping up and things of that nature. And most notably, outside of the toolkit, is that we now have a new way to sign into Zoom when you're doing mediations for the center. I've created a new email address, which is mediator.cmsmc. It's in the email. You don't have to try to remember me talking quickly. But you're going to use this login whenever you're doing a mediation, and that's going to automatically give you hosting abilities. Right now, that was a little iffy if you were a host or not, and sometimes it created issues. So this is a great workaround. In addition to being able to be the host for your mediation sessions, you'll be able to schedule your follow-up sessions. One of the complications that we've been having is people, it's best practice to schedule your next sessions while you're at the table. However, with no real way of knowing what's currently on the mediation schedule, that can cause some conflicts. So with this new system, you'll be able to schedule your own sessions, your follow-up sessions, and see immediately if there's a conflict or not. And a bonus for the center, that'll automatically go to our calendar, so we are aware of everything that's going on and there's no missed opportunities there. So outside of all of that, we have one more training in January, which is on Sunday with the Director of Community Mediation Maryland, Laura Charkoudian. She's going to be talking to us about the 10-point community mediation model. And of course, if for all of our newbies, this is mandatory. We're really eager to get those last hours under your belt for you so that you can really be in the process. So I know I talk fast and that was a whole bunch, so I'm going to be quiet. And if you have any questions, please let me know.
All right. So yeah, just again, reminder for the new mediators, Sunday, the 24th, 10 a.m. I think.
10:30.
10:30. Okay. And everybody should have gotten a Zoom link for that, as well as a follow-up email with a video to watch prior to that and a bit of reading to do. All right. Well, thank you everybody for coming, and we'll see you, if not on Sunday, hopefully next month for the next TSB.
Thank you.
Bye.
Bye.
Thanks, everybody.
Bye-bye. Thank you.